Members, before I call the next speaker, the vote on the urgency motion was incorrectly announced. The record will be changed to read the result as the ayes being 68 and the noes 51.
Mr. Speaker.
I call Carol Beaumont.
Thank you very much, Mr. Speaker. I stand and I intend to put a few facts into the mix today because we've just listened to the most ridiculous set of misleading half-truths and stereotypes and absolutely ridiculous comments from the Minister of Economic Development. But before I do that, I want to make a few points on behalf of myself and my colleagues. I want to reiterate the point that the Honourable Trevor Mallard made, that on this side of the House we value our creative industries. We take great pride in our creative industries. And if you look at the track record of the previous government, you will see absolutely chapter and verse about how we supported the creative industries in this country. So, first of all, fact, we support the creative industries, and ask the people who work in those industries about the last government and the support for their industry. Secondly, we want The Hobbit to be made in New Zealand. We want The Hobbit to be made in New Zealand and are glad that it is being made in this country. And like everybody else in this Parliament, and like all of the people in New Zealand, we are proud of films like Lord of the Rings, and I am sure that we will be proud of The Hobbit. So I just want to get that on the table as a matter of fact. Now, that's what's driving some of the polls that were referred to earlier. All New Zealanders want to see this film made here. But I want to dive beneath that and look at some of the detail here and try and get a few questions answered. Now look, we know that the creative industries provide jobs in this country. We know that economically they're very valuable, that the money that is spent in New Zealand, we also know the value for tourism. But we have to answer some questions. This whole debacle has been a major embarrassment for our country. Watching that government, those members across the House, acting in the way that they have in relation to Warner Brothers has been an absolute embarrassment for this country. What about the economic and political sovereignty of New Zealand? I intend to ask some questions on that. I intend to ask some questions on how members opposite handle disputes, because honestly, it is appalling. And where has the Minister of Labour been in a Labour dispute? Nowhere to be seen. Now, thirdly, I intend to look at the actual issues that were at stake in this dispute. And fourthly, looking at the actual nature of the bill before the House, the bill that we will be debating over several hours now, the Employment Relations Film Production Work Amendment Bill. So there are many questions to be answered, and I hope that we can see the media start to dig beneath all of the headlines and ask some hard questions of the government, because they need to be asked. And the public, once the public start to hear the answers to some of these questions, I think that you will see quite a different reaction to the one at the moment. Now first, on the issue of economic and political sovereignty, I want to know whether this government can confirm that labour laws should be changed in response to domestic concerns and issues. And maybe the Minister of Labour, if she's so inclined, could perhaps confirm to us that that is the case, that labour laws are a domestic matter and something that should be changed in response to our own domestic concerns and issues. And if not, on what basis should labour law changes be contemplated? That's my first question. The second question is whether the Minister is aware of other sovereign states that have changed labour laws in response to demands of foreign corporates. Let me say that again. Changing labour laws in response to the demands of foreign corporates. Now, I'm aware that in Southeast Asia there are quite a few examples of what are called export processing zones where exactly that's happened, where countries have changed labour laws to meet the needs of foreign corporates. But it is not something that I have seen happen in this country.
Point of order, Keith Locke.
But I can't hear Carol Beaumont because of the shouting, I think.
Well, order. Order. Humour's appreciated, but not on this particular occasion. Can I just say the member makes a fair point? This is a chamber of free speech, and free speech means people are free to speak and the members are able to listen to them. Order. I'm giving a ruling. Call on Carol Beaumont.
Thank you very much, Mr. Speaker. As I was saying, it's very important to consider why sovereign nations would change their labour laws in response to demands of foreign corporates. And the only examples I can come up with are around export processing zones in Southeast Asian countries. So perhaps the Minister of Labour, if she can be bothered, might answer those questions. Now, the other thing I'd like to know is whether we can get some confirmation that there are elements of our labour laws that will not be changed in response to demands by foreign corporates. Are we going to say that any item in our law is open to change if foreign corporates demand it? Perhaps, we could reduce the minimum wage. If some foreign corporate wants to come here but thinks it's too expensive to employ New Zealand workers, well, let's change the minimum wage, shall we, and say that it can be less for a foreign corporate. So this is about a government that seems willing to make changes to important domestic matters at the behest of foreign corporates. So that's my first lot of questions, and I hope the Minister will take the time to reassure us on that. Now, looking at the government's handling of this dispute, the Honourable Trevor Mallett has talked about the issues related to the incentives for film companies operating in New Zealand and has asked some questions there. And I just note too that Sir Peter Jackson raised questions in July of this year about the level of incentive. So why that wasn't being dealt with the government separately than this dispute, I have no idea. But somehow it has now become an outcome of this dispute. But I want to talk more about the issue of this so-called lack of clarity over the legal status of people working in the industry, in the creative industries. And my colleague Charles Chauvel, I'm sure, will deal with this in a lot more detail. But what I can say is there is no uncertainty. As others have said, including others across the House, a lot of the people in the film industry operate now as independent contractors. That is under no question. Nobody is disputing that. And the case that is referred to, the Bryson case, has not led to suddenly a whole lot of people's status being changed. So this is all a red herring. That 2005 Supreme Court decision has not led to a widespread change in the industry. So I don't know what the matter is that is requiring clarification by this bill, which is what we're told it's about. It's about clarifying the status. Well, actually, the status in the industry is quite clear, and the decision of the Supreme Court was quite clear. So it's not about that. This bill does provide a default provision. As I read the bill in the short time I've had it, what it does is it says, as a default, that people will be independent contractors. And it goes on to say who those people are, and it talks about actor and voiceover actor, stand-in, body double, etc. But then also goes on to talk about any person engaged in film production work in any other capacity. So that could be the person who answers the phones. Now, I'm not exactly sure that they really require clarification of status as an independent contractor, but I'm sure that that will come up further in this debate. I want to keep going with the questions that I've got to ask. I'm concerned that this bill will be used to undermine wages and conditions, and I want to know that that is not the intention. Independent contractors, when they are famous actors and so on, clearly are well-paid people and clearly choose that status. But any other person in the film production industry, it does not seem to me, benefits from the status of independent contractors. In fact, they would lose a lot of protections that exist under employment law, and they would be required to do a number of things like pay their own tax, pay their own ACC and so on. So there is a risk factor if this is intended to be extended and if it covers other than the people that are being